Check. 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 Check.
Brisk out there today.
I'm sorry? Oh, yeah. Yes, it is. 29 high today.
Yeah, it doesn't really move the needle much on the warm side either, so.
I'm sorry?
I said, it doesn't really move the needle much to get much warmer the rest of the day either. It stays about like this, a degree or two warmer, and that's about it.
I will not be going outside much today.
Check 1, 2. Check 3, 4.
And I'm assuming everybody can hear me okay? God, I wish these. Is there a. Yeah, I can hear myself coming through the speakers. I'm trying to get the distance at which I can come through the speakers the best.
Yeah.
I'm thinking here's good.
Yeah, usually about, 3, 4 inches is going to be your best. Just anytime you move away, you're going to start fading out. But that speaker is a good indication of how you're coming through. So
Are you okay if I do this the entire time?
that would be bad. Yeah. Yeah, that would be bad.
But funny.
That's
Might be
always
my
the
last day
challenge.
here, but it'd be a funny one.
Do we have a goal of order? Speaking of, online or in person?
Not a clue.
Okay. Of course, we'll just have to remind everyone to speak into the microphone appropriately as we're discussing it.
I will want to do that. And how are you this morning?
Good.
You ready for this thing?
Yeah. We're all ready. Audio mic check. I still have an occasional video kind of flakes out over there for some reason. For a second, it comes back. I don't know.
Is that you
What
on
to
the
do
right, or
is-
is that somebody?
No, that's me. Yeah. Mm-hmm. Yep. Check, check, 1, 2. There you go, this stuff in check, check, 1, 2. Yes.
time, I'm going to remind everybody to silence or put your cell phones on vibrate if you haven't already, and that includes other devices that may cause feedback and disrupt the electronic portion of this hearing. I'm also going to remind you that if you are speaking today and there is a microphone at your desk, please be sure the little green light is lit so that everybody can hear you, including those people that are participating via the web. Now, this is an on-the-record presentation concerning the stipulation agreement filed and titled as Full Unanimous Stipulation and Agreement in the Commission File GR-2022-0179, which is captioned as, in the matter of Spire, Missouri Incorporated, doing business as Spire's request for authority to implement a general rate increase for natural gas service in the company's Missouri service areas. My name is John Clark. I'm the regulatory law judge presiding over this on-the-record presentation, and it is being held on, today is November 18th of 2022. We are in room 310 of the Governor Office Building, and it is currently 9:02 a.m. As you can see sitting next to me, the chairman, Ryan Silvey, is present for this hearing. We also have several commissioners participating via WebEx. And so far, I have heard from Commissioner Holzman and Commissioner Coleman. Are there any other commissioners present at this time?
Commissioner Roop is present.
Thank you, Commissioner Roop. Other commissioners may join us or as is necessary or as they're able to. At this time, I'd like counsel for the parties to enter their appearance for the record, starting with Spire.
Good morning, Judge Clark. Matt Applington on behalf of Spire, Missouri, Inc., 700 Market Street, St. Louis, Missouri, 63101.
Thank you, Mr. Applington. On behalf of the staff of the commission.
Good morning, Your Honor. Kurt Stokes on behalf of staff, Kurt with a C, C-U-R-T, 200 Madison Street, Jefferson City, Missouri.
Thank you, Mr. Stokes. On behalf of public counsel.
Don Kleiser, on behalf of the Missouri Office of the Public Counsel. My contact information can be found in the record. Thank you.
Thank you, Mr. Kleiser. On behalf of Midwest Energy Consumers Group.
Tim Opitz for Midwest Energy Consumers Group.
Thank you, Mr. Opitz. On behalf of Missouri Industrial Energy Consumers Group, MIEC. Okay, they are an intervener in this case, but I do not hear them, and they may join us or they may not be present. On behalf of the City of Kansas City.
Good morning, you all. Matt Gelati with the City Attorney's Office, City of Kansas City, Missouri.
Thank you, Mr. Gelati. On behalf of the Missouri School Boards Association.
Yes, good morning, Judge and Commissioners. This is Terry Jarrett of Healy Law Offices, representing the Missouri School Boards Association. My address is 306 Monroe Street, Jefferson City, Missouri.
Thank you, Mr. Jarrett. On behalf of Clearwater Enterprises.
Yes, Your Honor. Stephanie Bell with Ellinger and Associates, 308 East High Street, Jefferson City, Missouri, 65101.
Thank you, Ms. Bell. On behalf of Constellation New Energy Gas Division.
Thank you, Your Honor. Joshua Harden with the law firm of Collins & Jones, PC, 1010 Foxwood Drive, Raymore, Missouri, 64078.
Thank you, Mr. Harden. On behalf of Symmetry Energy Solutions.
Good morning, Judge. Peggy Whipple and Douglas Healy online of Healy Law Offices, 3010 East Battlefield, Suite A, Springfield, Missouri, 65804.
Thank you, Ms. Whipple. On behalf of, did I call Vicinity? I don't believe I did. On behalf of Vicinity Energy of Kansas City. Again, they are an intervener in this case. They do not seem to be present at this time. On behalf of Wood River Energy.
Good morning, Your Honor. Alex Goldberg on behalf of Wood River Energy.
Thank you, Mr. Goldberg. I believe that is all the parties and interveners we have. Is there anybody I've missed?
Excuse me, Judge. This is Diana Plusha of the law firm of Curtis Hines. Garrett and O'Keefe on behalf of the MIEC.
Okay, thank you very much. So Missouri Industrial Energy Consumers Group is represented here today. Thank you.
Commissioner Kochmeyer's here.
Thank you for letting me know you're here, Commissioner. Now, I'm going to begin, as is indicated, this is an on-the-record presentation regarding the stipulation and agreement that was filed. I'm going to allow, is Spire going to be, who's going to be providing, I guess, an overview of the stipulation first?
Yes, Your Honor. Matt Applington, I'll be doing that.
Okay. This is an informal procedure. I'm not going to be swearing anybody in unless there are witnesses that need to take the stand. If there are witnesses that need to take the stand, I will swear those witnesses in. Please, if you're going to be presenting on the stipulation agreement, please come up to the podium and speak into the microphone. Be sure that the microphone is on. Be aware that as you speak, at any time, the commission or myself may have questions for you, and we will interrupt you to ask those questions. So, Mr. Applington, if you would, please come up. I'm also going to say, before we go on, that the stipulation and agreement, I saw nothing in it that was confidential in nature. However, if we are going to get into any information that is confidential, I may not recognize it right off. So I am relying on the parties to let me know if something that is confidential comes up so that we can go in camera to address that. Is there anything from council before we begin this presentation? Okay. Mr. Applington, on behalf of Spire.
Very good. And for Your Honor's awareness, I do not anticipate anything confidential coming up today, but we will keep our eyes open for that.
Thank you.
Come on in. Do you want to get Mr. Kaufman's appearance?
I do, thank you. I was just getting ready to do that. Mr. Kaufman, would you please enter your appearance for the record?
John B. Kaufman, appearing on behalf of Consumers Council of Missouri. Apologize for being late.
Thank you very much, Mr. Kaufman.
We're glad you're here. And we are glad to be here. We're very pleased to appear before the commission this morning to present the full unanimous stipulation and settlement agreement that was filed recently in Spire's general base rate case. And I'd like to start by thanking not only the commission and Your Honor for your patience and for taking the time to allow us to address you this morning, but I'd also like to thank the parties. This is, like most rate cases, a lengthy, at some points difficult process, and we've worked very well with all the parties, and I appreciate everyone's diligence and attention to bringing this case to a conclusion favorably. So thank you to everyone here. The stipulation that we filed is intended to resolve all issues in the case among all parties. The signatories to the stipulation are Spire, Missouri, the staff of the commission, the Office of the Public Counsel, Consumers Council of Missouri, MECG, MIEC, Symmetry Energy Solutions, Constellation, Clearwater Enterprises, and Wood River Energy for purposes of the transport tariff only with respect to Wood River. Three case parties, the Missouri School Boards Association, Vicinity Energy Kansas City, and the City of Kansas City, are not signatories to the stipulation, but have indicated that they do not object to it. Therefore, the stipulation may be considered unanimous by commission rule. I have a cite if you need it. To rewind a little bit, staff's filed revenue requirement in this case at the time of rebuttal was $71 million, which did not yet at that time include any true-up period plant or other expense additions. The stipulation calls for a black box style settlement with a net revenue requirement of $78 million, which is approximately half of Spire's original filed position in this case of $151 million, and includes, the 78 does, $19 million of ISRIS revenue roll-in for plant additions through September 30th of this year. This agreement sets fair and reasonable rates based upon updates to cost of service items and additional information from almost 8 months of discovery and discussion amongst the parties, and is the result of extensive negotiations among all parties. If approved, the stipulation would result in modest total bill increases We project for average residential customers of approximately 3.7% for Missouri East residential customers and 5.4% for Missouri West residential customers, inclusive of current ISRIS rates. The rate design set forth in the stipulation also aligns the residential fixed customer charge to $20 across the state, which is a $2 per month reduction for Missouri East residential customers. The affordability of our service is always at the top of our minds, and that's why we do know that many customers are struggling with high inflation and the circumstances in the broader economy today. That's why we're very pleased to include the following provisions as part of this stipulation. The funding for the Payment Partner Program will be increased by $1 million to $3.3 million for the program overall, with a full 50% of program revenues now being funded by Spire shareholder dollars. Eligibility for the program will also increase from 200% of the federal poverty limit to 300% of the federal poverty level, with future expansion up to 80% of the state median income. Funding for the Critical Needs Program will be increased by $250,000 to $500,000 to stand up the program in conjunction with United Way. And I would like to mention, I'm particularly proud that we are increasing the eligibility for these programs. That is a theme that came through loud and clear for us during local public hearings, and we're very glad to include it in the stipulation. The stipulation also fully resolves all issues relating to capitalization of overheads. Spire resumed capitalizing A&G overheads on October 1st of this year at the new, lower, agreed-upon rates dictated by the staff overheads audit ordered in the company's last general rate case and based upon the special time studies performed by the company since that time. The stipulation sets a 15-year amortization period, as recommended by staff in this case, for both eligible and ineligible A&G costs deferred to the regulatory assets pursuant to the Commission's prior orders. This amortization period will mitigate rate impacts to customers from previously capitalized items moving to expense and calls for rate-based treatment of deferred overheads that would have been properly capitalized, but no rate-based treatment for deferrals of expense items. Because this settlement is a black box, it does not require that any return on equity or capital structure be specified. However, the stipulation does set a reasonable pre-tax overall rate of return of 8.25% for purposes of interim ISRIS filings prior to the company's next general rate case. This rate of return is
Could you say that percentage again, please?
8.25. The 8.25 is comparable to the level approved by the Commission in other recent utility settlements. The stipulation also calls for greater transparency and accountability from Spire in a variety of areas, with the following provisions. Improved plant records and reporting, including a third-party audit of Spire's continuing property record. Additional reporting, record-keeping, and data collection to facilitate future staff audits and class cost of service studies and potential new rate design issues. And increasing direct assignment of shared services costs to add greater transparency and accountability to the corporate allocations process. We have several marketers with us today. The stipulation deals with some transportation tariff items. It consolidates our legacy transportation customer classes into one set of tariff sheets statewide. Among other things, these new tariff sheets improve the language around when and how Spire may call operational flow orders, makes provision for how to handle transport customers without a retail gas marketer, and clarifies how we will use meter data to manage imbalanced billing during any future OFO periods. Stipulation also sets an appropriate baseline level of property tax expense against which we can apply the new statutory property tax tracker in future cases. Finally, I would note one consideration for this settlement is a target rate effective date of December 26th of this year, and I think we're on track for that. Again, I'd like to thank the Commission for taking the time to allow us to present the stipulation today. With me today, I have Scott Weitzel, our Vice President of Government Regulatory Affairs, who's available to answer questions, as I am, and we have several other subject matter experts joining us via WebEx in case there are particular questions on particular areas. Thank you.
Thank you. Are there any questions from the Commission? And I have no questions for you at this time.
Thank you.
On behalf of the Commission staff.
Good morning, Your Honor. May it please the Commission, I'm Kurt Stokes on behalf of staff. I would like to echo Spire's comments. All the attorneys, all the parties participated extremely diligently in the preparation and filing of testimony and participating in local public hearings, in settlement negotiations. No parties just walked away. There was a lot of persistence and diligence in reaching this settlement, and it was reached after a great amount of discovery and hearing from a lot of folks at the local public hearings. So we wanted to thank everybody for their participation in that one. As Spire indicated, this settlement does provide for just and reasonable rates. There is an increase of $78 million in the annual revenue requirement. 32.4 approximately for Spire, Missouri East, and 45.6 million approximately for Spire, Missouri West. As Spire indicated earlier, one big provision in this settlement is reaching a resolution of the overheads issue that's kind of a carryover from the previous rate case. We address both the amortization overheads and excess ADIT through that provision. The parties identified approximately $17.3 million in eligible overheads that will be amortized over 15 years and will receive rate-based treatment. The parties also identified approximately $25.5 million in ineligible overheads, also to be amortized over 15 years, but receiving no rate-based treatment. The settlement continues to provide for an ISRIS, an infrastructure replacement surcharge. The two requirements for that are a pre-tax rate of return. The 8.25% is very close and consistent to what staff's filed testimony would recommend. It also provides for the required customer counts for East and West to establish the actual ISRIS charges. Looking at how you put those overheads and the ISRIS together, Spire noted that it began capitalizing things in October of 2022. That is consistent with the stipulation provision, which states that that the rates taking effect under this stipulation would reflect rate base additions through September 30th of 2022, and that Spire's next ISRIS filing would reflect capital additions beginning on October 1 of 2022. There was also new legislation passed this year. Section 393.400 requires utilities to establish a property tax tracker. This stipulation does provide that. It provides the required agreed-upon base level of Missouri property taxes used to set rates beginning with the effective date of rates. And it also addresses how to track the property tax appeals from the legacy Missouri property tax tracker that was in effect from April of 18 through December of 21, and also any future property tax appeals. This provision, or the stipulation, also carries forward a lot of other provisions from previous stipulations and cases. Staff notes that depreciation rates will remain the same in this case as they were from the previous case. Pensions and other post-employment benefits are accounted for in the stipulation. That's actually a good amount of volume of the stipulation. The parties have agreed upon the appropriate billing determinants and retail revenue per rate class, and as well as class allocation and rate design issues. It addresses a compressed natural gas issue that staff had identified in its testimony. There are additional provisions for low income. We note the payment partner program increases and the critical needs program budget increases, and we also have we recognize that the cost allocation manual docket is a separate proceeding, but we do agree that certain items will be addressed in that CAM docket. This is kind of a memorialization and reflection that issue is continuing to move forward. Staff identified, and I think other parties identified, issues with meters and Spire's meter replacement program. As Spire indicated, this settlement does address that in a just and reasonable way. The cost recovery of meters is consistent with how the commission dealt with the issue in the previous rate case. Going forward, it also has provisions on making sure that the issues that staff identified and other parties identified will be addressed and should be resolved. Also, issues with data collection and retention for both cost allocation and rate design. There are a lot of important provisions in there. They're very technical, so I'm not going to go through unless the commission has questions on those, but they are incredibly important to staff. The other issue that we have in this, continuing commitments from previous rate cases that include surveillance reports, spreadsheets, and annual general ledgers. We have the number and type of unmetered lighting customers, which was an issue in the last rate case. That's resolved now. Spire will continue to not include plant held for future use within its rate base. We addressed the propane cavern provisions from an older rate case, GR 2013-0171. That continues to go forward. One of the commission's orders from the last rate case was to include a class cost of service study in Spire's next general rate case. I think that the timing on that didn't really work out with this one, but we are carrying that forward. And we also have a provision to require allocated work papers and daily demand data provisions in that class cost of service study. And then finally, a continuing commitment from Spire to report to both staff and Office of Public Counsel on Spire's efforts to move customers to correct rate classes. Those are all continuations of previous commitments that Spire has made from other rate cases that we're carrying forward with this stipulation. Spire did mention the continuing plant record audit. There was a lot of work done on this one to get the scope and the cost on this provision correct, and to try to take a kind of take the pulse on Spire's continuing property records and see, how deep do we need to look. I think this provision will be very helpful in helping all the parties do that. On the direct assignments versus allocations, the parties worked really hard to build a provision that provides the right incentives for Spire to increase the number of direct allocations without tying any particular party's hands on what, that number of direct allocations have to be, direct assignments versus allocations have to be. Finally, there are updates to the transportation tariff. Staff position in testimony was to preserve the status quo, but staff can support the transportation tariff revisions in this case. It's a reasonable resolution. As Spire indicated, there are clarifications on when and how an OFO can be called, and some other clarifications that move things forward. The two provisions that are really important to staff are payment responsibility, and there are two parts of that payment responsibility that made it workable for staff. The first one is that it actually works, and the way an OFO penalty works previously was you looked at the nominations for a pool and you compared that against the usage by a pool. And previously those, unless it was an individual transportation customer making a nomination, those nominations were just spread out an entire pool of customers. You couldn't identify individual transportation customers who had nominated a certain amount of gas. And therefore, the OFO penalty could not be allocated to individual customers because the nomination for that individual customer was not available. With this new transportation tariff provision, the marketers will be required to allocate during an OFO period or a period of curtailment period those allocations among those individual customers, and that makes that calculation possible. Now, the other end of that calculation is the usage by customer. And there are additional telemetry requirements and provisions in this stipulation that, again, it makes that OFO penalty provision actually work. The second reason that this payment responsibility provision works is it allocates the risk properly within the three relevant parties. You've got, under the transportation tariff provisions, You have Spire itself, you have the marketers, and you have the transportation customers themselves. And the risk needs to stay within those three parties. And that's exactly what this provision does. It doesn't allocate the risk to those non-transportation customers who are not a part of that. It still allows, obviously, the marketers and transporters to allocate risk among themselves by contract, but as between Spire and the marketers and Spire and the transportation customers, the tariff still allocates risk to the individual customers, transportation customers. The other major update to the transportation tariff is the OFO penalty provision. And while we're maintaining the actual penalty calculations, the commission should note there's two additions there. One is a provision allowing for waiver of the penalties under appropriate conditions, and a provision that would allow the parties to open up a new working docket if either the Kansas Corporation Commission or FERC re-examines their OFO penalty provisions. And there are three reasons that staff can get on board with the transportation provision there. And again, it goes to risk shifting. First, as between the actual transporters and marketers and Spire's non-transportation customers, it's important that the risk be allocated appropriately. The OFO penalty is not just a pass-through of gas costs. It's an actual penalty provision. The provisions for passing through gas costs are actually taken care of in a different provision of the transportation tariffs. The operational flow orders and periods of curtailment occur when there is an actual a threat of risk to the system integrity of Spire's system. And risk is not free. And so we need to allocate that risk among the parties that have the ability to control it. Spire's non-transportation customers, so residential customers, small commercial customers, those customers do not control gas acquisitions or nominations. They can only control their usage. In contrast, gas transportation customers, gas marketers, and Spire do control those things. So the risk of over and under deliveries should be borne by those transporters, marketers, and Spire, because those are the entities that have the ability to control that risk. The OFO penalties provision here continue to do that. And going forward, when we're looking at the waiver or the potential amendment of the OFO penalty provisions, staff would continue to consider that risk shifting between transporters and non-transporters. Second, staff considers the allocation of risk between the state of Missouri and other states. So OFO penalties are not something that Missouri alone provides for. Kansas also has OFO penalty provisions, and currently, Missouri's OFO penalty provisions mirror those of the relevant transportation tariffs approved by the Kansas Corporation Commission. And what that means, just basic economics, is a state that has a lower or a different OFO penalty provision will have a different level of risk. And by mirroring the KCC and Missouri PSC penalty provisions, we're ensuring that there's an equal amount of risk on both sides, and so it's just and reasonable that way. Third, there are risks upstream and downstream. So Spire is a distribution system, but there are upstream providers and interstate pipelines that have their own OFO penalties on file with FERC. And again, the Missouri OFO penalty provisions here mirror those at FERC. And that ensures that the upstream and downstream risks are equivalent and just and reasonable. Now, again, I say that these transportation tariffs have two provisions: one a waiver provision, another one to open up and re-examine them if certain events occur. The waiver provision, the standard is good cause, and so good cause in staff's mind would encompass an examination of all relevant factors, including those three considerations I just walked through. And I think those same considerations would be at work if we open up a docket to re-examine these OFO penalty provisions. That we would want to make sure that we're addressing all three of those along with any other relevant risk factors. But you know, given the improvements both to the clarity of when an OFO can be called, the increased communication between Spire, transportation customers, and marketers, and the increased telemetry and other provisions that really improve this transportation tariff, staff is able to fully support and recommends adoption of these new transportation tariffs. So that's all I have for today. Are there any questions?
Any questions from the commission? I have just a few. Before I go into those, I'm going to say you've done a good job of undercutting the questions I was going to ask by preemptively answering them, which is always good. I was very concerned about how responsive. I mean, I was obviously at all the local public hearings, as were you. I was very curious to know how responsive to the public this agreement was, and it appears that it was reasonably responsive to that. I'm also very pleased that the parties were able to work together and bring this prior to the hearing. There's nothing quite as frustrating to me as getting the feeling that the parties really aren't communicating until they see each other face to face on the first day of the hearing. So I applaud everybody on that. Now, in a normal rate case filing, there's usually 50 plus tariff sheets that are filed, and I believe with this one originally there were 8 tariff sheets, primarily centered on the transportation tariff, which I believe got a lot of the interveners involved. And you've gone through some of the changes to the transportation tariff, which sound like they're pretty major. And while not explicitly said, are a lot of these changes to respond to a Winter Storm Uri type event?
I think Winter Storm Uri got us to look closer at these OFO penalties. It made it, directly relevant. I don't want to say that the transportation tariffs are just a reaction to Winter Storm Uri. I think they're designed to be, more forward-looking and comprehensive than that. But Winter Storm Uri is definitely a triggering event. From staff's perspective.
Okay, thank you. Now, in regard to you had indicated in regard to the waiver of the OFO penalties that these provisions apply to kind of across the board, but there is a waiver for good cause, I believe you said. Who holds that good cause determination? Is that Spire?
No. The tariffs expressly require a finding of good cause by the commission, and that was important to the staff, that the commission would be the ultimate arbiter of what good cause is and is not under the transportation tariffs. I don't have the citation with me, but there were some FERC waiver cases that arose from Winter Storm Uri. And there was a I can't remember if it was a concurrence or a dissent by Commissioner Danley at FERC that talked about the importance of FERC being the deciding factor, the deciding body on what good cause for waiver was, and not the utility. And so, it's very important to staff that the transportation tariff provisions have the commission as the entity that decides whether those are waived or not. And that is in the tariff.
Thank you. You had also indicated that this involved some changes to the cost allocation or CAM manual, and that's a separate docket. Does the resolution in this case in any way move towards resolving that?
I don't want to say it moves toward resolve. It certainly doesn't get in the way. I think it frees up party resources to then now focus on the CAM instead of the rate case, if that helps.
And I guess my final question for you, unless another occurs to me, and this is going to sound like an interrogative question, but it is not. It is a genuine curiosity on my part. I've read this again and again, And I guess what I want to know is why did a rate case become necessary merely a year after the commission approved new rates for Spire?
So I think, from staff's perspective, I think the overheads issue was really driving a big part of that. We recognize the need to address that issue early on. Obviously, staff doesn't decide when a rate case is filed. We respond when one is filed. I think, given the resolution of the overheads issue, I certainly understand the financial motivations that Spire would file another rate case to resolve that issue as soon as possible.
And all of those overhead issues are resolved with a 15-year amortization, is that correct?
That's right, and the eligible items that would have been capitalized, those are given rate-based treatment. The expense items, the ineligible items, those are not given rate-based treatment. We think that's consistent with general rate-making principles.
And the compressed natural gas is not in this rate proceeding, but they're free to argue it in a future proceeding, is that correct?
Right. There were enough issues that staff identified with the compressed natural gas. It was, I don't think it's understatement to say it was an extremely messy analysis, and so it was clean, and we appreciate Spire's work with this just to exclude the cost of those CNG stations from rates right now. And with a closer look, Spire can refile in the future. But you're right, that it's not in the case under the stipulation, but it doesn't prohibit Spire from, coming in with a new request in a future rate case.
Okay, thank you. I have no further questions. Thank you very much, staff.
Thank you.
On behalf of the Office of the Public Counsel.
Yes, Your Honor. Thank you. Most of what I would have to say has already been very well said by both staff and company, so I'm going to keep my remarks relatively short and focus on just two issues that are resolved by this stipulation. The first concerns the indirect allocation versus direct assignment, or the Spire CAM issue that Your Honor just mentioned previously in discussions with staff. That issue is one that has existed through several cases now, and we do fully expect that that issue will require additional evaluation as part of the ongoing Spire CAM case. However, as part of this stipulation, actually, let me back up and just explain very briefly. One of the primary concerns that the OPC has had, and it is expressed in both this case and the prior Spire rate case, concern the level of direct assignment versus indirect allocation, with the OPC arguing that a higher amount of direct assignment should be being performed by the company. One of the provisions in this stipulation effectively sets parameters to strongly encourage Spire to ensure that a higher degree of direct assignment is being carried out related to at least its employee costs, its wages and payroll costs. We view this, meaning the OPC views this, as a good step in the right direction towards potentially resolving the long-term concerns that we've had related to the direct assignment versus indirect allocation problems, the CAM problems in general. This does not fully resolve all of those issues. Again, we expect that those issues will be considered further as part of the CAM case and will require additional compromise and discussion and review. But that at least gets us moving in the right direction as far as the OPC is concerned. The other issue is related to Spire's meter replacements. As Your Honor may or may not be aware, in the last general rate case, a concern arose regarding the speed at which Spire is replacing existing diaphragm meters for new ultrasonic meters. There was a disallowance ordered by the Commission, as well as the Commission requiring Spire to put forward additional information related to, in general, its replacement strategy, as well as the lives that it was seeing regarding these diaphragm meters that it was replacing. As part of this case, that issue arose again. However, this stipulation is an attempt to, if not directly resolve that, at least provide an avenue for future resolution through the existence of the audit that has been referenced by both staff and company. The goal here is that by the time the next Spire general rate case occurs, which we all hope will not be in the next year, there will be additional information as necessary to help us more fully resolve that issue, to have a cleaner understanding of the extent of a problem, if a problem exists, and to provide a reasonable resolution for fixing that all parties can agree to. So I just really wanted to touch on those two specific issues. I would echo again what's already been said regarding the degree of willingness of all parties to work very closely and work really diligently into reaching a full resolution in this case. There was a great deal of respect provided by opposing counsel for the company with regard to understanding where parties were, what their drop deads were, what the requirements were for getting to a settlement, and that is what allowed us to achieve a settlement in such a timely manner. And I thank counsel for Spire, counsel for staff, and others for working so hard on getting that settlement out there.
Thank you. Any commission questions? I have just a couple questions. I'm going to work backwards and start with the meter replacement that I know is a major concern for staff. In the stipulation agreement somewhere it says Spire, Missouri staff and the Office of the Public Counsel technical experts shall meet with the goal of agreeing on the precise format of data, the frequency and manner of reporting, and related items. And that appeared to be what you were talking about, possibly getting some of resolved before the next rate case. But since these are centering around reporting requirements, is there any kind of contemplated timeline in regard to everybody agreeing on what the format of the data is?
So 2 points. The first, and I want to clarify what I was saying, Spire currently anticipates, I believe, completing, or at least being predominantly completed with its replacement of meters related to at least the Spire East service territory within the near future, hopefully before the next rate case. The OPC is of the opinion that by the time that rollout has occurred, we will hopefully be in a better situation to understand exactly what exists regarding unrecovered diaphragm meter accounts due to the nature of the existing separation of diaphragm and ultrasonic meter accounts in Spire's books. So effectively, as the rollout of new ultrasonic meters occurs, I believe that the issue will become cleaner and clearer to all parties, just as a matter of course, so to speak. Now, that being said, the additional information that is being discussed as part of the stipulation is certainly going to help making sure that we have a full and complete picture of that whole circumstance. So to directly answer your question, I believe in the same paragraph, and I apologize, I'm operating a little bit from memory here, it addresses the idea that there was a deadline for a filing of the agreement for what the reporting information would be, with provisions to allow any disagreement to be submitted to the commission first through the mediation process set forth in commission rules, and then ultimately for a final commission decision if, for whatever reason, parties aren't able to agree. I invite one of the other parties to correct or identify the exact timetable for that. I apologize.
Your Honor, this is Kurt Stokes with staff. Page 15 of the stipulation identifies, and I apologize, it might be a typo. It says February 15 of 2022. I think that should probably say February 15 of 2023, if I can get.
Agreed.
Thank you. I missed that. I appreciate that.
And actually, if you look at the bottom of page 14, this is paragraph 30E, requires a meeting no later than 2 weeks after the effective dates of rates in this case to discuss this issue, and then the February 15th, 2023 deadline that staff referred to.
Thank you very much. Mr. Kleiser, the second thing I'm kind of curious about is in the direct assignment of costs, which, as you indicated, was another important issue for public counsel, there is a disallowance of amounts for the test year in a future rate case. Can you give me an overview of that and why you believe that's necessary?
All right, so I'm going to try and keep this as brief as possible. The OPC has in the past and in this case raised concerns with the belief that Spire is not properly directly assigning as much costs or directly assigning much cost as it should be under its CAM. Okay, as a sort of very brief background, in general, the cost allocation manual, or CAM, requires a company to first directly assign as much cost as possible, and then if it cannot directly assign a cost, to indirectly allocate costs following cost causative principles, and then finally, if it cannot indirectly allocate costs following cost causative principles, to generally allocate costs. That is the sort of framework under which a CAM, specifically Spire's CAM, is set up to operate. The OPC's position has been that Spire is not directly assigning as much cost as it should. And I'm not going to speak for other parties, but I think that some might share that same opinion. Yeah, I don't want to speak to other parties, though. The goal of that provision has been to try and encourage the company to increase the amount of direct assignment. Now, we specifically chose wages and payroll because we felt like that was an area that was most easy to directly assign costs, basically using more or less timekeeping standards that you would find in just about any other major company, just like any lawyer would do, keeping track of their time. The goal here was to ensure that in the next rate case, we had hopefully a higher degree of direct assignment, and that we could, using that information, kind of develop a better way of potentially working through other cost assignment areas. The disallowance is there simply because, as I've already said, the existing CAM requires Spire to directly assign costs as much as possible. Now, Spire's, I assume, of the position that it is meeting that requirement. The OPC disagrees. In order to facilitate settlements, we basically set this up so that there would be a rationale or a reason for Spire to work towards that goal, if that makes sense. Does that answer your question? I'm not sure if I completely answered your question.
It does answer my question. Thank you.
Okay.
I don't have any further questions. Thank you, Mr. Kleiser.
Thank you.
If it has not become obvious already, I am going through the list of signatories to the agreement first. So with the remaining signatories, if you have something, I would like to hear it. Consumer Councils of Missouri.
Good morning, Your Honor. Chairman Silvey. Commission, we are pleased to be here today in support of the stipulation and agreement in this case. Indeed, it was a serious and diligent negotiation with a lot of give and take. We are satisfied with the general economics of it, but I also wanted to highlight again some of the special programs, customer programs in this case. And before I do that, I want to thank the Commission again for holding local public hearings, including 2 in-person public hearings. We think that these serve a very important public purpose. Even it's not always easy sitting there listening to hours of testimony and some difficult testimony, but it helps to sometimes hear directly from customers and from people who deal with customers that have special problems. And in this particular case, I think we have in the record, in the transcript of those hearings, some very compelling testimony about people who are in difficult situations that need help, and we have as well some testimony that helped us kind of craft these programs and talk about how these programs can meet these issues, including the eligibility issue, which we're going to be tackling very soon with Spire. And we want to thank Spire for how well they've collaborated with us in the last few years. They have been very easy to work with. For the most part, we haven't had to bring any disputes to the Commission yet. And we are particularly thankful that Spire has stepped up and agreeing to contribute more shareholder funds into the Partner Payment Program and the new Critical Needs Program. we think it's very important to establish this as close as we can to a 50-50 contribution. This is I think a policy that is very positive. It recognizes that poverty and these issues are everyone's problem, and everyone is contributing towards it. So we're looking forward to seeing what we can do with the partner payment program and the new critical needs program, which is primarily a program that looks at families that have serious illnesses, have a sudden onset of that, and trying to find solutions that help those folks. We are also pleased with the negotiations we've been having with Ameren, Missouri, and these utilities have been meeting together with all the stakeholders jointly to prepare for a critical needs program that may be launched even yet this year. So, we're very positive on that front, and I don't know that I need to address anything else, but again, thank you, and we're happy to be here.
Any questions from the commission? I don't have any questions. I would like to thank you for giving me an overview of what's going on behind the scenes.
Okay.
And I am happy to hear that everybody took into consideration what occurred at the local public hearings. Midwest Energy Consumers Group.
Good morning, Your Honor, Commission. Midwest Energy Consumers Group is a signatory to the stipulation. I want to echo the parties who've thanked everyone for working together to reach this agreement, and I ask the Commission to approve it. So happy to answer any questions.
I don't believe there are any commission questions, and I have no questions.
Thank
you very much. I'm glad to hear that MECG is in support of the agreement. Symmetry Energy Solutions. And you're also here on behalf of Constellation, is that correct?
That's correct. And
Will you be speaking for both?
as well as Wood River. I believe that Clearwater has their own statement that they would like to give.
Okay, thank you. Go ahead, Mr. Harden.
Well, thank you. Joshua Harden on behalf of the marketers that just named, Constellation, Symmetry, and Wood River. First of all, like the other parties, we would like...
We're having a little bit of a hard time hearing you. Can you get a little closer to the microphone?
Closer? Sure. Like everybody else, I would like to thank the parties for their efforts in reaching the unanimous stipulation and agreement in this case. Our statement here, too, I want to make sure it is solely limited to the issues involving the transportation tariff and no other part of the stipulation and agreement. In regards to the proposed changes to Spire's transportation tariff, we believe that they are a significant improvement over the existing tariff. The proposed transportation tariff provides the parties much-needed clarity during times of extreme disruption to gas supply and other threats to system integrity. The proposed transportation tariff before the Commission follows traditional rate-setting cost causation principles. It's a serious improvement to the existing transportation tariff, which ultimately resulted in very costly and inefficient federal litigation, as well as the multiple complaint cases here at the Missouri Public Service Commission. It also another beneficial side effect of the agreement is it reduces the possibility of entirely inappropriate cross-subsidization between classes. That being said, we do want to make the point that the proposed tariff is only an incremental improvement, and although a significant one, it is an incremental improvement and does not attempt to remedy what we believe to be a very clear problem with the existing OFO penalty structure. That current OFO penalty structure, not only in Missouri, but also in Kansas and in other jurisdictions, requires multi-jurisdictional collaboration and coordination to reach a rational policy solution for this issue. So Missouri is not alone in this challenge. Again, in our view, tying OFO penalties to market index prices during times of extreme market disruption results in absurd and meaningless results with no behavioral incentive whatsoever, a jurisdictional race to the bottom in OFO penalty multipliers, and what we viewed tied with Winter Storm Uri, extremely costly and inefficient litigation, ultimately. There's also some evidence that OFO penalties tied to the index price drove market prices higher during Winter Storm Uri, and Winter Storm Uri will likely not, unfortunately, be the last disaster that disrupts national gas supply and markets. So in conclusion, I want to make this short, we ask the Commission to approve the agreed-to transportation tariff. And we believe that it is, again, a significant improvement to Spire's existing transportation tariff. However, we also ask the Missouri Commission and its staff, and by the way, this is actually put into part of the tariff in terms of triggering a meeting or triggering some type of stakeholder process, to work with the marketers and other stakeholders as we continue to try to find multi-jurisdictional multi-jurisdictional solutions to the OFO penalty structure issue. We believe that to do so would be in the best interest of Missouri ratepayers and all stakeholders, including Spire. So with that, I'll be happy if there's any questions I can answer.
Any questions from the Commission? I don't really have any questions. You indicated that you are supporting this because you believe that these tariff sheets for the transportation tariff are an improvement. When you say that something is, just to give me a brief, better idea, when you say a multi-jurisdictional solution and you're not talking about at the federal level, I assume you're talking about basically multiple commissions coming to a similar agreement. Is that correct?
Right. So some type of arrangement where you basically don't have different states competing with each other on OFO penalties, which affects, obviously affects how decisions are made, but the short answer is yes, state commissions, as well as FERC.
Is that something that could be put similarly into tariffs in different states?
I wouldn't see why not. And again, I would compliment staff on what's actually in this proposed tariff to this effect that basically says, hey, if there's a change at FERC or with the KCC, that automatically triggers some type of stakeholder process here in Missouri. That's important. I think that's smart. I also don't know that it should be entirely reactive, and I would see that the marketers being more proactive in going to affected state commissions and saying, look, can we get on board? Can there be some type of multi-jurisdictional effort to make the OFO penalties not tied to the market index?
Okay, I can go down this rabbit hole a lot further, but I don't see it as beneficial to the stipulation. But I'm glad you think that this transportation tariff is an improvement. I know at the point these transportation tariffs were originally filed, that seemed to trigger a lot of the interventions. So, thank you very much, Mr. Harden, on behalf of your clients.
Absolutely, thank you.
Clearwater Enterprises.
Thank you, Your Honor. Stephanie Bell on behalf of Clearwater Enterprises. We also thank the parties and echo many of the comments that have been heard this morning for everyone's efforts to reach a unanimous stipulation and agreement. Clearwater agrees the proposed changes to Spire's transportation tariff meaningfully clarify the roles of each Spire, marketers, and the customers, and set expectations that will provide for improved interaction in both ordinary times and particularly during extraordinary times, such as what occurred during Winter Storm Uri. We also believe preservation of eligibility for transportation services to those Missouri West customers, both commercial and industrial, with annual usage exceeding 30,000 CCF is an important benefit to customers. For these reasons, we ask that the Commission approve the stipulation and agreement.
Any questions from the Commission? Okay. I have no questions, Ms. Bell. Thank you very much.
Thank you.
Those are all the signatories to the agreement. I don't know who we have here. Well, obviously, we have a few people like the MSBA. Is there anybody who is not a signatory to the agreement? I understand that under Commission rules, 7 days have passed and the Commission can't take it as unanimous, but is there anybody who is not a signatory to the agreement who wished to comment on the agreement? Okay, I'm hearing none. It appears that there is nothing else we need to go through unless there are any questions from the commissions that are outstanding. I hear none. Again, I would like to...
No questions, Judge.
Thank you, Commissioner Holzman.
Thank everybody for their diligent and hard work through this whole process. We're appreciative.
And that's what I was going to be getting to, too. It appears... One thing I heard again and again from the signatories as they got up is an appreciation for each other in regards to communication and not walking away from the negotiation table. So I'm very pleased with that. I don't believe there's anything further we need to go over for this on-the-record presentation. With that in mind, I will adjourn this presentation and we will go off the record. Thank you.